2 is the IFA administrative hearing. I'll be playing the hearing officer, so we're assuming the only people in this room are Norman, who's playing the father, Kamani Tuma, Ashley, who's playing the mother, Corazon Tuma, Marina, who's playing the nurse, Katie Langdon, Elizabeth is the DCF worker, Maria Freelander, who investigated and supported the 51A, and then Alina is the English teacher. So we'll conduct that first, and then we'll do the Superior Court argument where we only have attorneys. Lily for the department, Kelly for the parents, right? And then last, the temporary custody hearing, but only the legal argument, with Lily acting for the department again, Danielle for the parents, and Alana for Jamel, the child. Any questions before we start? No. By the way, on the first one, can I have a volunteer that's not participating in the first to be my assistant, ask who the parties are, and sort of the person that has ushered them into the office and so forth? Who wants to do that? That doesn't have a role in the first? Anybody? Okay, Kelly will. So,
are you doing the custody hearing first?
No, we're doing the administrative hearing. I just said it. We're doing the administrative hearing first, but I just needed a volunteer to, I'm already in the office. I'm the hearing officer. You're one of the, employees, the GCF employee basically. And so you're bringing them in, you're introducing them. Is that okay? Sure. Okay. All right. So let's start.
And you're
I'm who I am. Paul Collins. Say I would like to introduce everyone to Paul Collins. I'm the hearing officer,
okay.
and in the matter of.
Okay. I'd like to introduce everyone to Paul DeCaldis. She's the hearing officer with regard to the IFA case. Over here is Imani Tuma. He's the father of Jamil and TG.
Hello, Mr. Tuma.
Corazon Tuma, the mother.
Ms. Kim.
Katie Langdon, the school nurse.
Hello.
Maria Freelander, social worker.
Hello.
And John Martineau is an English teacher.
Hello. Could I have Ms. Freelander, if you would, to summarize the basis of your investigation?
Yes. So on January 10th, there was a 51A that was filed from a mandated reporter, that is the nurse, Katie Langdon.
Katie is sitting right here.
Yes.
And I'll hear from you in a little bit.
And she had filed this report because of possible abuse and neglect of plaintiff's son, Jamal, who's a 10-year-old at the Dracut Middle School, Dracut Middle School. And so I conducted the investigation, and
What did your investigation consist of? Who did you speak with?
I interviewed the nurse, Jamal, Jamal's sister, and Jamal's parents, and his sister's English teacher.
Okay.
And after interviewing the English teacher, I found out that Jamal's sister, TG, had, after she returned from Christmas vacation, she had written an essay, and in her essay she had written about New Year's traditions, and it was about sacrificing animals. And at that point, I was especially concerned about Jamal, because he had been sick for several days. He didn't go to school for 3 days, and the nurse had found out that he was sick and called his mom, and his mom said that she wasn't really too concerned about how he was feeling, and that, you know, it was flu season and that he should be okay to return back to school soon.
I'm sorry, did you go to the home?
I did not go to the home.
You just spoke on the phone?
I just spoke over the phone. I called the house and talked to Mrs. Tuma, and she said that he had a fever and that she wasn't going to take him to the doctors because it's flu season and he'll get over the sickness sooner or later. So then the following week, the nurse had Miss Langdon found out that Jamal wasn't getting any better and that they were getting ready to, Tuma family was getting ready to conduct an animal sacrifice. And so, since the family has neglected to bring Jamal to a doctor and just kept him home away from school, I'm in support of the nurse's filing of the 51A, 51B, because the parents have neglected the proper medical care, and I do have substantial reason that Jamal could become more sick and that his health is at risk and he's in danger if he doesn't see a doctor immediately.
All right. Miss Langdon, how did this family come to your attention?
I first learned that Jamal was not well from his English teacher because he had severe flu-like symptoms, and as a mandated reporter, I'm supposed to report once I see the probable cause of child abuse and neglect, and I believe that case falls into this category because Jamal didn't get back to school 3 days later, so I felt the responsibility to contact his
Did you see
parents.
him while he was in school, before he went home?
Before he was at home.
And what condition was he in?
He was not feeling well. He had flu symptoms, so he was sent home.
So you sent him home?
Yes, so I saw that, and I was concerned about him, so I called the parents, and I learned that the child didn't see a doctor. Instead of taking the child to the doctor and provide proper medical care, I learned from his sister that they were preparing an animal sacrifice to help Jamal get better. So.
And Ms. Martineau, you had reported to Ms. Langdon some concerns that you had?
My knowledge only go into what teacher. She's my student.
Who is TG?
Teaches Jamal's sister.
How old is TG, if you know?
TG is 12 years old.
Okay.
And she is my student, and she returns from her Christmas break with the essay that was required for kids to express how they spent their vacation, Christmas vacation. And in her essay, she mentioned that our family participated in some kind of a animal sacrifice. And when I wanted to explore this a little bit with TG, she explained to me that the family practices the ancient Ifa religion, which originated in Yoruba, which is now in Nigeria. And part of this religion is the animal sacrifice, and particularly for this holiday of when they observed that 2 animals were sacrificed, one goat and rooster. And I mentioned this fact to the nurse, to Katie.
How does the practicing of this religion affect the Tuma's failure to obtain routine medical care, if you know? Actually, I probably should be asking the nurse that.
Well, instead of providing a proper medical care, which we are all used to that, the family makes a decision to commit a ritual, to perform a ritual to sacrifice an animal, and that animal is, that the sacrifice is supposed
sorry, Mr. and Mrs. Tuma, I know you're both anxious to speak as well, and I want to just ask you first, do you know why you're here? Either one of you can answer that.
Yes,
Why?
because we understand that the department is saying that the practice of our religious belief is not how can I say this? Well, the department feels that we have been abusive to our son, and we of course argue that that there's not reasonable cause to believe the report of abuse and neglect.
I wonder if my assistant Kelly could help with that. That he's not technically correct, and I want you to alleviate his fears as to exactly what's going on here procedurally. It's not that the department is stating that the parents are abusing the child, correct?
Right. This hearing is, I believe, for giving you the opportunity to rebut anything that both the nurse as well as the social worker have revealed as possible abuse. This is your chance to be heard as far as why you are conducting and raising your children in this manner, and why it would be in the best interest of your son.
And you know that you're here because you asked for a fair hearing, and you have a right to a hearing relative to the department's decision to support the initial 51A report that you as a family were not providing your child routine medical care. So that's where we're at, procedurally and legally. But I'd like to hear, as a family, I've heard from the other participants here about the religion that you practice, but could you tell me about the religion that you practice? Either one, Ashley, Mrs. Kim.
The religion that we practice is, we have a tradition that every New Year's Eve we sacrifice an animal, and we sacrifice different animals to different gods to make sure that we do good deeds and that we stay healthy. And it's not that we're not providing medical care for our child, we're doing what we've done for generations. That this is how we were raised, and when we got sick, you sacrificed an animal, and our son didn't want to go to the doctor, so we were providing for him as best as we could.
Mr. Tuma?
Yes.
Could you add to that as well?
Well,
What sort of treatment are you giving your child if it's not going to a traditional Western doctor? I understand he's still sick, so what sort of treatment is your family giving Jamil?
well, we believe that by sacrificing to our gods.
Who is the Babalao?
The Babalao is a priest.
And does he help, or will he help, or do you believe that he will help with your child's treatment?
We hope, we certainly believe that, and upon his return from road trip to North Carolina, yeah, well, that's, my brother, boy's uncle.
What are Jamil's symptoms right now?
He has I guess a fever and a sore throat that was getting better, and he has an issue with is an ear issue.
So he still has a fever, he still has a sore throat, his ear is bothering him, general flu-like symptoms that have been not resolved. And you still believe that that
was
you're,
starting.
I'm sorry?
He was
It's-
starting to get better.
Okay.
He was still running a fever, but his sore throat was going away. And his left ear was still bothering him, but he wasn't complaining about it as much. So if he was getting better, we had the preparations for the animal sacrifice so that he, hopefully the fever would be reduced and the earache would go away. And we wouldn't be going against his wishes, and also we'd be keeping with our cultural tradition.
So, Ms. Friedlander, what exactly is the department's concern here? It appears like this child has the flu. Would that not just take its, toll in terms of?
Well, our concern is that if this continues, the two must continue to deny their child access to proper medical care, that he could face substantial risk or serious physical injury if he doesn't see a doctor in the future. Maybe this flu will run its course, but who's to say that if he becomes sick again someday with bronchitis or strep throat or whatever, and he doesn't get medical treatment, that he could develop a much more serious illness.
Now, I know that you're not a lawyer, but and I know that the department has regulations revolving around failure to obtain medical care, but it seems like this family has some fundamental rights relative to practicing their religion. Don't those rights override the department intervening and making a decision that their failure to obtain Western medical care is in fact a reasonable cause that abuse or neglect may have occurred?
In this situation, it's a balancing test. They do have fundamental rights, First Amendment rights to practice their own religion, but in this case, what's in the best interest of the children is that they have access to proper medical care, and their practice of animal sacrifice is not routine medical care by any means. And
What is routine medical care? And maybe the nurse can answer that as well. What is routine medical care?
Routine medical care, it's when the symptoms appear, the parent's responsibility is to take a child to a doctor and see and check what it is. In this particular case, the child was complaining about his earache, which can be an ear infection, and this can affect his hearing ability in the future. Or if he has a sore throat, he can have a strep throat, which also have very serious consequences. And all of those constitute neglect and even abuse of the child. So, yes, they have a right to practice their religion, but they don't have a right to abuse their children and neglect their children. And
Ms. Friedlander, you said in your report that this was not a medical emergency.
correct.
Correct.
It's not a medical emergency, but as I have said before, we're concerned that if this sort of practice continues, the Tuma children will possibly face physical and emotional harm, and as a result of the practices and not getting any medical treatment and missing school is our concern as well. It just doesn't, it's not acceptable, the behavior
Well, I
and
would speak for the
conduct of the
Tumas,
Tumas.
but since you say it's not a medical emergency, don't they have the right to treat their child when the child is, has some symptoms, is sick, with the way they think is best for their child?
They do, but we're stepping in at this point because what's the best interest of the children? We don't believe that the best interest is to neglect the children and not bring them to a doctor and just let them stay home away from school and possibly become even more sick by not receiving antibiotics, medical treatment.
I'll allow the two months to have the last word here, so either or both of you want to let this hearing officer know anything else, now is the time.
Well, we've practiced this religion since the 16th century, and it's something we believe very strongly in, and we just feel that we should have a right to raise our child and practice our religion.
Mrs. Stewart?
I don't feel like we're neglecting our child. I'm home with him all day and I was seeking medical care and what I assumed is the best way possible for him and for the rest of our family. I don't want him to get sick. I want him to get better, and I honestly believe that by having following the IFA culture and the IFA traditions, it will help him get better.
Thank you. I'll decide this later. Go away. All right. No, the hearing officer obviously wouldn't say that if he lets you know, but I have to sift through everything and write my report. So let's decide it. So what's the crucial issue right here, Danielle?
The best interest of the child.
No.
Whether this constitutes.
Well, not the best interest. Go ahead.
Whether the.
Because I'm reviewing her,
You're reviewing,
right? I'm
right.
reviewing Elizabeth's determination of what, Elizabeth?
Of whether or not
Allegation.
What did you do procedurally? What did you do?
I supported the 51A.
You supported the 51A, so she
Right.
made a decision there was reasonable cause to believe there was abuse and neglect by caretaker, right? The Tumas appealed that decision to this fair hearing. So this fair hearing officer is reviewing that decision.
Whether it should have been supported.
Correct. Right. All right. So where are we with that? Any thoughts?
I wouldn't think it should be supported.
Why not?
I don't think it should be supported for a lot of reasons. One, it's the social worker, this has to be your proper, the worker mentioned, it doesn't seem like there's enough of a case here to establish that there's any, and it says actually in the paper, there is no medical emergency. Different people have some people, my mother stuck a sock in my ear when I was a kid, when I had an earache. So there's no medical emergency. When you're talking about the balancing test for the best interest of the children.
No, don't go there.
Oh.
Remember the
It's just the
standard,
hearing,
the
right.
threshold standard is very low for that determination
The
of
reasonable
reasonable
cause,
cause.
right.
Very low.
And
So keep it there.
Well,
You know
and-
what I'm saying?
antibiotics, just things that they're mentioning that should be done for the child is not, there's no evidence to support that that's what should be done, that the child's in any danger, that the child has any potential effects from having the flu.
Okay, somebody disagree with Daniel. Give me the other side of it. Alana.
Well, the flu can be dangerous. It can definitely kill people.
It
So I
could
think,
definitely,
yeah.
especially young children, right?
So where the threshold here is just the reasonable cause,
Mhm.
there is enough that it is especially dangerous to children, and that it could eventually kill him if they don't seek proper medical attention.
Tell me more, or it doesn't have to be related, about this notion of routine medical care. Elizabeth?
I just wanted to add on
Okay.
that although there's flu, he's appearing to exhibit all these flu-like symptoms, it could be that he actually has something more serious than just
Okay.
the flu.
Okay.
And
Or
as
could
far
be
as
just the flu.
Or,
Sorry,
yeah,
sorry.
yeah, Alina?
I just want to talk a little bit about what constitutes a reasonable cause.
Yeah.
Because a reasonable cause, it has to be based on factual evidence. It's not
Okay.
what could have happened, or what
That's
he
correct.
could have exhibited. It's what he is exhibiting right now.
Okay.
And a reasonable cause, like you said, it's not preponderance of the evidence or clear and convincing evidence, but it's evaluating the evidence of whatever. At this time, the department didn't produce any of the experts to say, yeah, the child is in the condition.
You don't
where-
need experts, it's just a fair hearing.
But there's no factual, the social worker didn't even go to the family to observe the child. All it is
Yeah, I
was.
wondered about that. I thought you were gonna say that you went to the
That I went to
home
the
and he was,
So-
feverish and he was vomiting. first they didn't wanna let you in, and then that you're gonna really play it up.
I thought I'd stick to the fact pattern.
Okay.
That's what we've been told in law school.
What would make, your decision change? How would the facts vary so that, the decision to support, to substantiate the 51A was in fact based on reasonable cause? How would you change the facts?
That it was supported?
Yes, yeah, what would you like to see?
Well, maybe if I had gone to the house.
Doesn't it say?
And if I had actually gone to the house and, you know, seen if maybe there were.
Tell me more about Jamil's illness. Well, how would you like to, not like, but how would that change so that your decision would then change?
He gets to the emergency room.
What's that?
All of a sudden, he's so bad that he has to be taken to the emergency room, and.
Well, they're not gonna take him to the emergency.
Oh, they're gonna get
They're gonna have the bubble outcome.
Yeah, I mean, if he gets like demonstrates symptoms that we recognize as really sick. I mean, he's burning up.
Well, one of the things that I think Elizabeth brought up is that right now they look like flu-like symptoms,
Right.
but you don't know what they are, and he hasn't gone to a traditional doctor, and a number of days have elapsed. He has a number of symptoms that could be something else other than flu. And Alana also mentioned that flu in and of itself can also be dangerous. So, you know, maybe if he was younger, maybe the passage of time, he's out of school for a number of days, and the school is really concerned, and no one is getting to see him, and they're hearing that they're doing, that the family is adamant about not taking him to a doctor and so forth. And remember, again, the standard is really low, too. All you're doing is you're not removing him, you haven't filed, anything in court, all you're doing is substantiating, like in the Cobble case, that initial report of lack of routine medical care.
And maybe if there was more from the sister here saying, I saw him feel this way or that way, because she doesn't really, there's not much in, the report that, or at least what we have from what the sister has seen other than, or.
Yeah, maybe the sister's coming to school and she's telling, the English teacher, or somebody's asking, how's your brother? Oh, he's still sick.
But you did interview the son?
I'm sorry, Danielle?
Did she did interview the boy though, right?
Yes.
Okay, I thought you said you had, sorry.
Alina?
But what I thought is that it has to be something extraordinary. Because sometimes, like a flu
That's right.
Symptoms,
Right.
sometimes you call in a doctor like I have at 10 years old, and they said, you know what, wait a
Just
couple of days.
exactly.
3 days.
Rest, drink
So
liquids,
it has to
etc.
be for some reasonable person, something extraordinary, not like flu-like symptoms, in order to create those factual base that needed to create a reasonable cause.
And you have to be careful as a social worker and as the department, which has, the goal of preservation of family and so forth, to also respect, the family's traditions, the family's beliefs, and what the family believes is best and so forth. So you have to be careful of, sociological and cultural, ethnic factors as well. But at the same time, recognizing that if there's reasonable cause, you have to go that route. All right. Now, what do we do next?
What about if the son texted one of his buddies and said, I'm really sick, but don't tell anybody?
Yeah, sure.
Can you let your kid have a cell phone?
Hypo.
Cell phone,
I was hypoing right back.
Yeah, but yeah, he's got an iPad, iPod, whatever it is. The one you put out.
So if the Tumas are not satisfied with the decision, what do they do? What do they do, Lily? They appeal it. So how do they appeal it? Because right now, this is, as I said, DCF offices are just an administrative, this is an administrative hearing, part of the agency sitting quasi-judicially. So how do you get to court?
You file a motion with Superior Court.
You file a complaint.
Okay.
Yeah, so you start a lawsuit, basically. And what you've done is you've exhausted your administrative appeals through DCF, and the next step is going to court. So it's the Tumas suing, basically, the Department of Children And so, all we're doing is I'm gonna hear from, shortly, with the attorney for the department, Lily, attorney for the parents, Kelly. And, so you're conducting just an oral argument. I mean, part of the case would be, you know, if you wanted a trial with experts and whatnot, but for purposes of our hearing today, you're just doing a legal argument. Who had a question?
I did.
No one didn't have?
Typically, the 72-hour hearing would.
We're doing that next.
Right, but typically it would come before any of these, right? Because it's within 72 hours.
If the department in fact files a care and protection case. If everybody following me? So for example, in the hearing that we just did was an administrative hearing. Look at the Cobble case. The department never moved for custody of Cobble's child. So the department never filed a care and protection case. What we're gonna assume shortly for our third scenario is maybe Jamil didn't get better. And so the department said, oh, we gotta do something, right? And either went in and yanked him, or, you know, filed and then had a temporary custody hearing. Do you understand what I'm saying, right?
So if that's what happened, then that would probably come first.
It probably would come, it'd probably come first in terms of the timing.
Right.
Yeah. Norman?
But, so what the hearing was just substantiating the B.
What we just
The
did.
B, the 51B.
Exactly, the 51A.
The
I'm
51A
sorry,
is a complaint.
reviewing the 51B decision.
The investigation.
Exactly.
Yeah, based on the investigation.
Yeah.
She made, you know, her finding, and so that's what the hearings do.
Yeah, and there's substantial evidence in the record to support that. And so now the Superior Court judge is doing the same thing, reviewing her. And it's governed by, remember, Chapter 30A, the Administrative Procedure Act. Elizabeth?
And the administrative hearing would be conducted by an officer from the department,
That's what I
or?
wanted to ask.
Yeah.
Yeah.
That's a little, so your
Does that
coworker.
seem-
Yeah.
How is that
Yeah.
impartial?
Agencies.
What's the outcome?
That's exactly
After
what I
they
was
find
wondering.
there are substantial
That
factors.
makes more sense.
What
Whoa,
did
Alina?
what did the department do after that? Yeah, they found that there are substantial evidence to.
Maybe nothing, because remember in the Cobble case, the initial review was that the 51B worker had reasonable cause to support. The department then offered Cobble services, and Cobble said, no, go away. And the department just closed the case, okay? In the scenario we're gonna do, we're then gonna assume that the department didn't close the case, got really concerned, Jamil became sicker, or maybe has some really, you know, serious illness. So, as in some of the cases that we read, the department goes for custody, files in juvenile court to get temporary custody of Jamil so he can be treated. So, again, it depends on the case, Alina. So right now we're doing just the Superior Court argument. So the Toombs have appealed. They hired a lawyer. Their lawyer is Kelly. So Kelly's just doing a legal argument, and Lily is responding to that legal argument. All right. So I'm going to expect you to, unlike the scenario that we just did, to rely on some of the cases. All right. Yes. So let me hear for the moving party first.
Do you want me to start?
This is, yeah, the matter of Tuma versus DCF. Parties, attorneys, please introduce yourselves.
My name is Kelly Rogers. I represent the Tumas.
My name is Lily Chow, representing the state.
I'll hear from you, Ms. Rogers.
Would you like me to begin with the facts? or-
Yes.
Okay.
Just briefly.
Okay. Your Honor, the Tumas are here today to review a 51A, 51B report by the department regarding the medical care given to their son, specifically speaking, not given to their son, as a result of their religion. The department has determined that by the Tumas not bringing their son, who is suffering from flu-like symptoms, sore throat and earache, to a traditional doctor, they are neglecting the needs and well-being of their son. They are
differentiate this case from some of the case law that's out there, custody of minor, McCauley, Twitchell case?
This case is quite different in the fact that Jamil, the son, is suffering from flu-like symptoms, as opposed to McCauley, custody of minor, where those children were suffering from leukemia, where it was determined that if medical procedure, traditional Western medical procedures, were not given in those cases, the child would die, and that was the only treatment necessary. Jamil, on the other hand, again, it's a sore throat, it's an earache, it's a fever. There's nothing showing that by not bringing Jamil to the doctor that he will die.
Well, speaking of dying, I'm reminded of the Twitchell case where the Twitchell's son was, had some symptoms such as fever and pain and so forth. And within a short period of time, the symptoms actually escalated and he did in fact die. And those parents had been relying on prayer, like the parents in this particular case. Couldn't this be a serious case? And how would you distinguish it from Twitchell? It's tough, isn't it?
Yes,
Well,
it is.
what about the standard of the lack of routine medical care? I mean, the department has regulations concerning, families not providing basic medical care to their children. Is it your contention that the family here should be exempt from those regulations?
No, but what the definition of basic medical care, and as far as the government intruding on the rights of the parents, on deciding what should be basic medical care for their family, is not necessarily the right way to go in this case.
Well, what's the standard that I should be governed by in reviewing this case?
There should be substantial evidence.
Okay, and how is it that you're arguing there isn't obviously substantial
Right.
evidence? How is there not substantial evidence in the administrative record?
Well, in the fact that, he's been home for a few days. He isn't getting better, but he's not getting worse. There's nothing to show that, antibiotics would necessarily treat him and make him better.
Let me hear from the department. Lily?
Your Honor, it's the department's contention that it's looking at the totality of the circumstances in this case, taking into account the boy's age, the fact that his condition has not improved, as well as the parents' unwillingness to take him to the
But here's my
doctors.
question, and the plaintiff has raised this issue, that basically the case law in Massachusetts regarding medical treatment of children revolves around real emergency situations where children are really in danger of losing their life. This doesn't appear to be this type of case.
Your Honor, I'd like to bring up that at this time there was a severe flu pandemic, or the flu was very, very bad this season. And I'd like to bring up that this boy was 10 years old, and children are more susceptible to flu and whatnot, and people have died from the flu. So in this particular case, again, he has not improved, and the
child is not involved as a party in this appeal, and I know that my task is merely whether I should affirm the department's decision if there's substantial evidence to warrant the decision, but I have a question. Right, Jamil is 10 years old. I hear he's a good student, et cetera. Does his decision, do his rights come into play at all in this case regarding his right to practice his religion? Should the department take that into account? When he is older and able to articulate that he's waiting for his uncle to bubble out to take care of him rather than go to a traditional, Western doctor.
Sure, his wishes should certainly be taken into account. However, Your Honor, I'm asking you to weigh out his interests versus the state's interests versus the parents' interests in this particular case. If you believe that it is necessary for him to receive the proper medical treatment for the flu. And what we would ask is to have the state grant temporary custody for, the sole purpose of him receiving medical treatment.
Okay, you don't need that right now.
Okay.
You just hold it, asking to affirm the department's decision, right?
That.
Now, last word from the plaintiff?
Although Jamil is 10 years old, the court can look to the child's interests as well. Again, 10 is, I think.
But I really don't have a right, I don't have the authority to do that within the context of this Superior Court case, do I? I have a very narrow issue to decide here, and that's whether the department's, Maria Freelander's decision to support the 15.A was grounded in the record, whether there was substantial evidence. So that's kind of a low threshold, isn't it? So you have a high burden
Right.
to overcome in terms of reversing
Yes.
that administrative decision. She does. So what does everybody think? Should the Superior Court judge affirm the department's decision or reverse it? How many affirm? Raise your hand. How many are affirming? Affirm. You just said yes, yes, and now you're not raising your hand. No.
Reverse.
I said how many are affirming? Oh, I'm sorry. None?
I guess you stand corrected.
I'm affirming.
Would you?
Huh?
Would you?
Probably, yeah.
You would affirm
Yeah,
the
yeah,
department's decision?
yeah. Only because it seems to be of some length of time. No one is actually seeing him. There's the flu and the epidemic, and you could have something else, and you could have leukemia. So I would be, and again, it doesn't mean that the department's gonna take this child. It doesn't, it just means that the department has, again, found reasonable cause, really low threshold. I know Danielle's footstep is shaking her head. How could you do that?
Doesn't mean that
I
they
just
don't
don't
agree with it.
I would certainly be respecting
Right.
their religion and so forth, but I would be concerned about the child's
I'm not even sure.
well-being.
I'm not even sure the
This is
religion.
gonna get more heated, because I wanna do the next one, because now we have.
Now I'm the lawyer.
We're actually, and we are in juvenile court, but now it gets serious, because now the department wants custody to, not necessarily to take him and put him in a foster home, but wants custody to be able to get medical treatment. So we're gonna have Lily again being the department's attorney, and Danielle, you represent the parents, and Alana, Jamil. So let's do it this way.
Can I just ask a quick
Yes.
question?
Yeah.
Why would it go to the Superior Court rather than District Court first?
Why would it go to the Superior Court? Basically, we're following the Cobble case
Okay.
procedure. And it has to do with the appeal under Chapter 30A
All right.
of the administrative decision. Okay.
Okay, thank you.
I just wanted to ask,
Yeah.
and I had said Superior Court, but, and you had, mentioned the Superior Court afterwards, but that would be the correct venue, the Superior Court rather than?
Yes, just like Cobble. What we just did
Yeah.
was the identical procedure in the Cobble v. DSS case. And remember that in that case, he took it all the way to the SJC, and basically the state wasn't looking to take his child, but he just wanted to be able to say that the state never had reasonable cause. I don't want to be in the central registry. I don't want anything to do with the state intervening in my life. They were wrong from the very beginning. So he didn't leave it alone, even though it wasn't in terms of custody or intervening. It wasn't such a serious thing. But the father said, no, that's not right. And so that's what the Cobbles were attempting to do here. So now, as I said before, it does get serious. The Cobbles, let's assume that they filed, Jamil is still sick, preparations were underway for the sacrifice, so they'll.
Okay, and there wasn't the Superior Court appeal then?
Well, as Danielle said, don't worry about that right now. Because that would have occurred later. That would have taken a while to get filed and argued and so forth. So we're now just at the 72-hour hearing, which would have been quick, because Jamil was only sick a week or 2. Let's make it 2 weeks. Let's say it's 2 weeks. He's been out of school for 2 weeks. Or do you want to say 10 days? It's 2 weeks. Okay, let's make it 10 days. All right, 10 days, and on or about, say, the 8th or 9th day, the department filed the parent protection case.
After they've already supported the 51B, now they're filing the CMP.
Yeah, now they've filed the CMP. We're going to be the temporary custody hearing just finished. We've heard from the Tumas that they've testified. We've heard from Katie Langdon, the school nurse. We've heard from Maria Friedlander, the worker. We've heard from Martineau, the English teacher. So that's finished, and now the court is just hearing the arguments of the attorneys, okay? So everything's on the record. Everything's on the record. Ready? Ready? Actually, Ms. Thompson, you can go first.
Which would be the fair preponderance?
Yes. Yes. Yes.
Sure.
Yes.
That is a little higher. We are definitely fighting against the department trying to take custody in order to force Jamil to receive medical treatment. There is nothing to indicate proper medical treatment for the flu. Most children that go to the doctors for the flu aren't prescribed any medication except for some over-the-counter drugs to ease symptoms anyways, which we don't believe in. He has a cold. Flu takes sometimes 2 weeks, 3 weeks to...
How should I be guided by, for example, the custody of minor case? Custody of minor, McCauley.
These are the ones that you're going to lay out also the best interest, and we can bring that up. Also where the state, if you're going to look to balance parents' natural fundamental rights to raise their children without any governmental interference, the interest of the child who has already spoken that he does not wish to see a doctor, even if he's 10 years old, he's not that sick. There's no medical emergency, which the department worker herself acknowledged.
But I understand he's still out of school. It's
Yeah,
now the 10th day.
Yes, he is
Okay.
still out of school.
All right.
Flu sometimes, just as it's a big flu season this year, it takes time to run. The state's interest is not, the parent's interest here tips the scale. Their fundamental right to raise their child the way they want to. Currently in this situation, there's no medical emergency, the department has admitted that. The child simply has flu-like symptoms, not necessarily even the flu. Medical doctors aren't going to treat him with any antibiotic for the flu. There's nothing they're going to do but tell us to do exactly what we are.
Well, what about the second factor in the McCauley case, the risk to the child's health if the requested treatment is not?
What is the requested treatment, though? The requested treatment is
Go
just to
ahead.
have him viewed by a doctor, which a mother is certainly going to understand her child better than a pediatrician that only sees the child yearly. The risk of the child's health and life if treatment's not ordered, there's no treatment that's even being directed here. There is not a course of treatment for the flu, besides bed rest, which is what he's doing.
Alana, you represent the child. Is your position the same? Is there anything you would be adding or?
Okay, well, the model in mask is contracted, so we're gonna do what the child wants in this case.
Then that's your client, Jamil.
Yes, Jamil, and he has made it very clear that he does not wish to seek medical attention. He would rather wait for his uncle, who is a priest in their
And what
religion.
would the uncle be doing?
Praying
Praying.
to the gods, yes.
Okay.
So I think that that's how they would typically go about treating any type of illness. I also think that it is important to note that in the Twitchell case, there was a precedent set that when a child is in danger, you have to seek medical attention. It was very clear from the social worker's report that this was not a medical emergency. So therefore, the state and the department needs to take into consideration what the child would want in this case, and it is not a medical
Is it,
emergency.
that may be true that the initial report, the 51B investigation did state, and I reviewed it, that it wasn't a medical emergency. But isn't there sort of a gray line between when it becomes a medical emergency? I mean, you mentioned the Twitchell case, reviewing that after the fact, after the poor child has died, it really is, it's hard to pinpoint the exact time
Right.
when it becomes an emergency and the state should step in.
Right.
So what do you do?
There are 5 factors that were listed in the McCauley case, I believe, and one was like the child's age. Typically, if someone were to die from the flu nowadays, it would be slightly younger. It would be more of a toddler or an infant to be seriously affected. Another question we need to ask ourselves is, if he doesn't get medical treatment, will he die? What is the likelihood of him surviving this? Typically, as the attorney for the parents pointed out, there's no treatment for the flu. It's a virus. You didn't get medicine for it. Most parents don't even take their children to the doctor for a simple flu. So I think in this point, that kind of gray area hasn't been crossed just yet.
Daniel?
Another point that the social worker seems to also be focusing on is the physical and emotional harm to the boy for the parents' religious issues. Seems to be relying on that more than the medical purposes for trying to take custody of its child. And the parents, again, their fundamental right to be able to practice their religion and with their child and their family without the interference of the government, I think outweighs the state's interest.
Thank you. Let me hear from the department.
Your Honor, the state is asking for you to grant the department custody for the sole purpose of the boy receiving medical treatment for these flu-like symptoms because his symptoms have not ceased, and he's been on.
Can you repeat his symptoms again?
He has strep throat, his ears.
Oh, we don't know that.
No.
That is strep, so.
Objection.
He had, his throat was, he had
He has a sore throat.
He has a sore
Okay.
throat. His ear was hurting, although he wasn't complaining about it.
Does he have a fever?
Yes.
So he's had a fever for 10 days. I think I heard the school nurse earlier testifying about that he's had a fever for 10 days. Okay. All right.
For 10 days, that's not exactly a good thing, so, we're asking the board to grant the department, custody so he can receive medical treatment, although I understand that, it may not be flu per se, it very well could be something else.
Let me ask both the parents and the child's attorney here, if this court were to order legal custody to the department and allow Jamil to remain at home, still receiving the traditional treatment that your family and your religion believes in, but at the same time requiring you to take Jamil to a pediatrician, either one, what are your thoughts about that type of decision?
I think that this may be more negative to his emotional and physical mindset than him not seeking medical treatment, just because he's not typically gone to a doctor for anything with illness. It's all been taken care of by their spiritual leaders and their religion. So I think this would actually be kind of a very negative effect on him and what he believes in his entire life. So it could lead to some type of emotional breakdown as to what's going on. Everything he's known thus far is now being completely changed. His religion's at stake. He's maybe start to doubt his parents. It could actually be more emotional troubling for him than it would be for him for us to just let the flu, take its course.
Danielle?
I agree with the child's attorney. I think also that if you look at the department's intervention with this family, most of it's supported by the religious practice, and that's what it's being guided by. And that the child obviously has appropriate medical care in order to be in the school system. I'm assuming for the fact pattern, right?
I'm not understanding the last piece that you mentioned. The child, repeat that again?
About the child having medical care?
Appropriate medical.
Yeah, I'm thinking that from the fact pattern, I didn't get that he never goes to the doctor, so I would think he would have his immunizations. In order to be able to be in public school, he would have been receiving medical treatment. That's a
But you haven't answered
routine.
my question. I think the child's attorney has pretty much said that that decision
Be harmful.
would be harmful. Would the parents go along with that decision?
The parents would they go along with the decision to bring the child to a pediatrician?
Right.
No, they would not agree with that. They would not agree to that. They don't feel that there's a need for the child to be going to the pediatrician at this point.
There's no question as to the parents' unfitness. So, I mean, if they are trusting, if the department believes that, every other aspect of their parenting is on par, there's no issues of any neglect or abuse, then I understand where the issue is with how they're choosing to treat their children based on their faith.
Well, pursuant to 11924, one of the allegations of improper parental supervision has to do with mental neglect. So I'm assuming that at some point, unless this case gets dismissed by the department's probably going to be going forward to a hearing, to a final hearing. Lily, is that correct, or?
Yes, again, we believe that it's a pretty fair compromise to want temporary custody for the sole purpose of Jamil getting medical care for these symptoms, because again, this season, the flu epidemic was pretty severe, and he should be seen by a pediatrician. There is really a question about parental unfitness, because,
But it may become so if this case
Right.
goes to a hearing. Let me ask the parents and the child's attorney.
The child's already getting
I just
there.
want to read from one of the decisions of the custody of a minor, the Twitchell case, had to do with the findings about the metabolic therapy, and that was not only, and I'm quoting verbatim here, was not only medically ineffective, but it was not consistent with good medical practice, and that such treatment was contrary to the best interest of the child. So how, if at all, would you distinguish that case?
And that child was sick with
Leukemia.
minor with leukemia.
Leukemia, yes.
Right. This is
And it was the Laetrile
Right.
metabolic therapy
right
case.
therapy. We're not giving our clients are not giving their child any inappropriate substitutions of, and as in that case, where the parents were giving them a potential toxic cocktail of drugs to the child. This child's already getting better.
But as in all of these lines of cases, it seems to be that the department's contention is that the family here is not affording their child what's consistent with good medical practice, as the cases say. And is that enough for this court to order custody temporarily?
You'd end up issuing temporary custody to every child that had a cough and a sneeze and parents weren't taking them into a pediatrician to be checked out. These are children in most of these cases that had life-threatening illnesses that had already been documented. And here we have a child that has already started to get better. His sore throat is already starting to improve. He's showing signs towards improvement, and there is no treatment for the flu. So there's not going to be anything to gain from seeing a pediatrician.
Thank you, Councilor. I'll have the department has the last word here, so.
Well, I would like to disagree with that just because it's possible that it can be something else. And, you know, they said that if flu-like symptoms, so you're right, it may not be the flu, it could be something else. So again, I think it's the department believes that it's in the best interest of the child to get proper medical care or to be seen by a doctor, at least just to confirm that it's not anything life-threatening or serious.
All right, thank you. Now, in this case, because it's a 72-hour hearing, and because of the nature of the maybe emergency, the judge really has to make a decision. So let's make a decision.
Right there.
Yeah, I mean, I would be
Right.
writing my findings later on, but, you know, the decision has to be whether the department's gonna, you know, they need to know before they leave
Is that
what's going on.
appealable too, that judge's decision?
It could be, there's a procedure, Mass General Laws, Chapter 211, Section 3, that actually is kind of popular in family and in children's cases, because ordinarily, think about appeals, they're usually, you know, after trial. But, you know, for example, parents lose custody, you know, and it sets the stage for, you know, a long time. So because it's such a fundamental right that you're talking about, they can initially go to a single justice of either the appeals court or the SJC, and that single justice sits almost like a trial court. You know, it's a quick appeal. You're still doing a brief, but it's a very quick thing. It's like a trial brief. And that single justice can afford relief right away, afford relief, deny relief, or sometimes those single justices actually certify questions to the entire court, you know, to answer if it's supreme public importance and that sort of thing. So in answer to your question, yes, yeah, especially where, you know, parents are losing custody of their children. So what should the court do now? And what does it depend on? Marina?
It depends on the Jamil's condition, how he feels
On
about
Jamil's
this.
condition.
Yes, and maybe we can obtain a promise from parents if his conditions if he becomes feeling worse, he will.
So what if the court today, again, heard testimony that, again, that it's the 10th day, let's see, we said he had a fever, it still has a fever, sore throat, earache, not going to school, going to do the animal sacrifice, what else?
Would that be something that could?
Wait, we're reviewing the record, we're trying to decide what to do, because we have 5 minutes, so I'm looking at the time. What are we gonna do? You're all the judges,
I don't think there's enough evidence.
Preponderance of the evidence.
Fair.
Right? Preponderance of the evidence. And remember, it also, has the department also made reasonable efforts? So what would those reasonable efforts be? It would have to do with the, you know, the department sort of investigating, in this case, saying this is an emergency, you know, situation, and he has to obtain some medical treatment right away. So what are we doing? Do you want to do show of hands?
What about if you consider 110-1103 and the list of emergency medical care, and the last one has to do with condition that if left alone, you know, the potential for it to get worse?
That's exactly what I'm saying. That's exactly what, it sounds like what the department was contended, that it could get worse. It could get worse, it could be something else, right, Norman?
Yeah, and so I would say, you know, I mean, erring on the side of conservatism, that I would probably, you know, give custody to the state to allow the medical evaluation.
And again, in the medical cases, custody doesn't mean you're taking the child from the home. Custody just means, remember the definition of custody under 119, Section 21. It means now the state is acting as a parent, but
the parents are still the physical
So
custodian.
the state has legal custody and the parents
Yes,
remain,
yeah.
maintain the
In,
physical
in
custody.
some of these medical neglect cases, because the state isn't gonna pull the kid that otherwise loves his or her parents. Parents, for all other purposes, are obviously caring parents that are doing what they feel is best. But because the state is concerned in the health and safety, et cetera, of the child. So again, just like the scenarios that we just did, it really depends on what particular facts the judge and the hearing officer has heard. And factors, as you've seen, like in McCauley, the age of the child, what the symptoms are, whether they fall within the department's regulations, whether under the totality of the circumstances, the department, has substantial evidence that there's reasonable cause to believe that the child has been medically neglected, in spite of the parents' rights here, in spite of the parents' religious rights, that, when you perform that balancing test, what's the most important, and I cut you off at the beginning when you started to say best interest, but that's really what's behind everything, right? So I emailed everybody a new syllabus with dates. I apologize. I had actually, if you went and really looked at the dates, I think I must have been superimposing last year's dates or something, and it was crazy. You would have been, what is she think? She can't even consecutively. So we have plenty of time. We're able to do almost everything. We're not doing mental health. Next week we're doing adoption. So there's a revised syllabus on your email right now.
On Tuesday, there is a juvenile court judge coming into the class that takes place in this room right before this class.
Pat Flynn?
Yes.
I'll be there.
So here's the thing. We have a really large class, and when I mentioned bringing this class in, everyone moaned in our class. And our professor said, I said, there's not that many, because three of us are already in that
I've
class.
been here before when Ann O'Connor does.
Yes, so
Pat Flynn in.
because we have so many people, they really didn't want like the whole school knowing about it, but she said that everyone in this class can join. If they wanna come, they can ask questions, and, so yeah, that's Tuesday at 11 o'clock.
Cuddy won't let me have all
Yeah,
that.
some people have class, but I'll pop in and say hi to,
Want me to record?
I used to carpool with Judge Flynn in law school.
Yeah, oh, I'm
She's
assuming
great.
it's what it is, yeah, okay.
I'm assuming it's her, and she does a great overview of the juvenile
I thought it would be good
system.
for this class to maybe if you guys can make it, have the opportunity to come in.
Maybe I'll see if she can stay a little longer.
Well, we get out, the class is from 11 to 12:15. So I just wanted at least to let you guys know that. You can get her lunch.
Yeah.
I'll see what I can do. All right, Elizabeth?
Question. With something like this, could you file a CHINS, I know we haven't gotten there yet, and a child in need, a CHINS and care and protection?
Yeah, the child's been out 10 days, so the supervisor of attendance at the school may end up filing a CHINS case. And we will talk about those later on. That's a child in need of services, and there are 4 ways you can get into the court on a CHINS, and that's one of them, a truancy complaint.
How do you think this would have gone?
It depends, right? It really depends. It depends
On the
what
judge
evidence
or
the-
on the evidence?
On the,
How about what
on
we
the
had
evidence.
today?
Both, right?
With what we had today?
Mhm. I think for the initial supporting of the 51A report, there might have been reasonable cause. But in terms of custody in the 72-hour hearing, that's really iffy. I think so. Norman?
How did you decide to write this whole fact pattern, based on?
I make these things up. I should be writing novels.
We just did the religion and animal law class.
What?
We just did this religion and animal law case.
You did?
Yeah, it was an animal law case about them trying to build a church.
Oh, yes, yeah,
To
yeah.
sacrifice
That's a
the
Supreme
animals.
Court case. What was the name of it? I forgot.
Oh, the Church of the
People case. Well, they were leaving the carcasses all over the town.
but it wasn't this religion.
It was. What was it? It was the other one it was called.
Santeria.
Oh, yeah.
Practice Santeria, but this is.
Norman, tell the class about that book real quickly. I gave Norman a book to read.
Hey, there are pictures in there.
The way of the
I looked at this and I had nightmares. No. Well, you know, basically, this is a white guy. And I was
Right.
wondering, I mean, this was,
Yeah.
you know, but this guy at the age of 31
Mhm.
kind of poo-poo going to this Sunday reading, essentially you know, a fortune telling by one of the Babalao ones.
Mhm.
Babalao.
Yeah, you've got it. Babalao.
Babalao. And so he just became, you know, I mean, he just got into it. And so this guy himself is a Alulu, which is the highest form of the Babalao.
The writer of the book.
Yeah.
Yeah, yeah.
And so, and you know, they're into, the three big tenets of Orissa is ancestor worship, I'm sorry, it's the, ancestor worship and the divination.
Yes.
Anyway, it was pretty, I didn't read much of it, but, you know.
How long did it take him to get up to the?
Well, he wrote this, I think, in 74.
Yeah, it's an old book.
But I mean, so he started at 31? Religion?
Oh, no, he wrote this in 93, but he got into it at 74.
Okay.
I mean, you know, he was 33, he said he was very rich, so, you know.
Someone else did?
But, and so they predicted, you know, this Baloo that they saw, you know, said that he was gonna, like, you know, basically go broke, and he did. So the things that they purported, you know, happened, but, you know, the thing that he did through, you know, his accepting this religion was that he just lost any ability to be fearful, which is kind of interesting, you know. I mean, you know, like you get in an airplane and you fear it's going to crash. Well, you know, so it was pretty interesting, but I don't want to read too much because I didn't want to like convert.
Just one more
Thank
thing.
you, Norman.
One more thing,
Elizabeth?
Professor called us about the final exams. I checked downstairs in the library to see what was on file, and it's 2004 back to 97. So if you could perhaps put something more
Up to
recent.
2004 is what they have?
Yes.
Oh, okay. The hard copies with the library?
Yes.
Okay. By the way, when you see the revised syllabus, I plugged in for the last day of class a review. Because I always usually have time for the review, so I got rid of some stuff so that we have time for doing the review the last day of class. Okay.
All right. Have a nice weekend. Thank you.
So was that okay in response to Elizabeth's question that, you know, I mean, will we see